So my paper kind of fits with the theme of legal history in unexpected places in two ways. And the first goes back 30 years to when I was studying land law and frankly struggling with it. So I used to sneak off to a different corner of the library every so often and dip into the stash of detective fiction there. And one day I did this to take a bit of respite from land law, only to find Peter Wimsey in Dorothy L. Sayers' Unnatural Death saying, "Isn't there a new Law of Property Act?" And I checked the date, and yes, it was written in 1927, and it was the 1925 property legislation to which he was referring. So I'd always had it in mind to sort of come back and look at this a bit more seriously. And a couple of years ago, Daniel Monk was editing a collection on inheritance and sort of from an interdisciplinary angle. So I started kind of looking at detective fiction from the Golden Age to see how inheritance featured. So read all of Christie and Sayers and Marsh and some of Allingham for the period. I found that inheritance really did play quite a big part in the plots, as you might imagine. But my focus today is on just two of them, going back to Sayers and Unnatural Death to look at her very explicit treatment of legal development, and pairing that with Christie's The Mystery of the Blue Train. So this is my second example of legal history in unexpected places. And it was so unexpected and so hidden that even though that I was reading the novel looking for inheritance plots, I didn't really realise on my first reading how closely Christie was reflecting some of the legal debates that were happening at the time. And it was only sort of when I really clocked on to the fact that she was quite in tune with what was going on legally that I went back and reread it and saw new depths in it. So there's sort of three phases to this talk. I'm going to just briefly outline what the administration of estates did, and then how both Sayers and Christie pick up different aspects of the Act in their plots. So briefly, it simplified the law on intestacy. So previously, prior to 1926, you had different rules for real and personal property in the event of a person dying intestate. So land would pass to the person identified as the heir under the common law rules. Personal property would be divided between spouse, children, or in the absence of issue to the next of kin. So 1925 Act basically brings together a uniform set of rules that are much closer to those that had applied to personal property beforehand. It also therefore prioritised the surviving spouse. Now, I'll come back to exactly how it did so when I look at the Mystery of the Blue Train, because it's key to that. But in essence, in many cases, the spouse would receive everything where the estate was small. And if the deceased had not left issue, then the spouse would get a life estate ahead of any other relatives. Third element was that children inherited equally, regardless of age and sex, which is one of the reasons why it's sort of celebrated in the Women's Legal Landmarks book. And finally, it narrowed the range of relatives who would inherit. So it sets out a specific list of relatives who will inherit in the absence of a spouse or issue. So, and these are in order: parents, siblings of the full blood, siblings of the half blood, grandparents, uncle and aunts of the full blood, and uncle and aunts of the half blood. And in the absence of any relatives within the class listed, subject to one very important point that I'll come on to discuss in a moment, the residuary estate was classified as bona vacantia and went to the Crown. Now, it's this latter change that lies at the heart of unnatural death. So the scenario here is that Mary Whittaker has been caring for her elderly great-aunt Agatha for a number of years. Agatha, who is predicted to have only a few months to live, has not made a will, partly because she's unwilling to contemplate her impending death, and partly because she just assumes that Mary will inherit automatically under the intestacy rules as her next of kin. When Agatha is found dead, the doctor is suspicious, but the death appears natural, and there's no obvious motive for Mary to have murdered a dying woman to inherit just a few months earlier than she would otherwise have done. And it's only when Wimsey recalls reading a newspaper account of the 1925 Act explaining how it would curtail the claims of remoter relatives that a motive for murder presents itself. So they discover that Mary, having learnt about the Act, believed that there was a possibility that she would no longer be entitled to inherit, and so took steps to ensure that Agatha died before the commencement date of 1st of January 1926. So Sayers spends quite a lot of time talking about the Act. But there is a flaw, because a great niece in Mary's position would actually still have been entitled to the estate under the reformed intestacy laws. So although a great niece isn't explicitly mentioned, Section 46 of the Administration of States Act has to be read in conjunction with Section 47, which provided that the issue of relatives listed will take the share that their parent would have done if living. And legal writers Mortimer and Coates confirmed in their 1927 work, The Law and Practice of the Probate Division of the High Court of Justice, that a great niece or nephew would in fact be included as the issue of a brother or sister. To be fair to Sayers, the Act could have been much more clearly drafted, and some contemporary accounts did reflect a degree of confusion about the effect of the new law. So in 1925, November, the Daily Mail ran a piece called Lawyers Return to School to Learn Intricate New Act, which wrongly claimed that in default of any relatives closer than first cousins, the property would go to the Crown. And a few years later, there was an exchange in the letters page of the Times, in which one correspondent claimed that a first cousin would be barred from inheriting, only to be corrected a few days later by a practitioner. So it was entirely plausible that an individual in the position of Mary Whittaker might not want to run the risk. The property lawyer Robert McGarry was perhaps unduly unkind in griping that modern novels into which the law intrudes usually make lawyers wish that the law had kept out, since Sayers' characters do acknowledge the possibility that the term issue in the new Act will encompass a great niece. What Sayers does show very clearly is the impact of changing long-settled expectations about how the law would operate. As Agatha's lawyer explains to Wimsey, she simply couldn't believe that any law or court would be so wicked as to give the money to anybody other than her great niece, when she was clearly the proper person to have it. And while there's some humour in her demanding why the Duchy of Lancaster should have any right to it, as she tells her lawyer, "I don't even know the Duke of Lancaster," there's also a serious point here. The intestacy rules are intended, at least in part, to reflect the assumed intentions of the ordinary individual, and testators are unlikely to have wanted their money to go to the state. Now, Christie's The Mystery of the Blue Train was published the year after Unnatural Death. And in the opening chapters, we learn that the wealthy Ruth Kettering is contemplating a divorce from her unfaithful husband, Derek. She has, however, taken no formal steps to this end, nor has she made a will. Upon her subsequent murder, Derek accordingly benefits to the tune of a couple of millions, as Ruth's father grimly informs Poirot. Now, it's really clear that Christie was aware of the 1925 Act and the changes that it had made to the intestacy laws. The Mystery of the Blue Train was actually a reworking of Christie's earlier story, The Plymouth Express, which had previously been published in 1923. In this earlier version, the murdered wife had made a will, leaving everything to her husband. With the passage of the Administration of Estates Act, Christie could simply let the new intestacy rules do their work. Now, technically, it should be noted, Derek would not have been absolutely entitled to the entirety of Ruth's estate. His only absolute entitlement would have been to the statutory legacy of £1,000 and her personal chattels. He would then have had a life interest in the rest of the estate, with Ruth's father, Rufus, being entitled on his death. That, however, would have been scant comfort to Rufus, given the unlikelihood of him outliving Derek. And so it's understandable that Christie doesn't trouble readers with this particular nuance. But I think, read against the terms of the 1925 Act, The Mystery of the Blue Train does obliquely question the newly privileged position of the spouse under the reformed intestacy rules. And there are quite a number of factors, other than his infidelity, that raise questions as to the justice of Derek inheriting all of Ruth's money. First, that money was not generated during the marriage, but was given to Ruth by her father at the time of it. Given that Rufus is still alive, justice might suggest that the money should return to him. Second, Derek is upfront about the fact that he only married Ruth for her money in the first place. And third, by the end of the novel, he has fallen in love with and is planning to marry another woman entirely. I think any one of these factors by itself might call into question the fairness of a spouse being privileged over other family members, and combined they make a powerful case against it. Now, both the Great Aunt in Unnatural Death and Ruth in The Mystery of the Blue Train could have made wills, and this in itself is worthy of note. The salience of wills in Golden Age detective fiction tells us something about the kinds of families being depicted. They are wealthy enough to have assets to leave, but it's generally new money rather than a landed estate that is subject to entails or settlements that constrain freedom of choice. Within landed families, there would have been complex settlements that could not have been changed. Now, this, of course, is convenient for the purposes of the plot. You want sufficient ambiguity as to who might be able to inherit to be able to sort of cast doubt about who any potential murderer might be. But it does also reflect the profound changes in the ownership of land that have been taking place since the 1880s. The historian David Cannadine has pointed out that in the years immediately before and after the First World War, some 6 million acres, 1/4 of the land of England, was sold by gentry and grandees, with the figure being nearly 1/3 in Wales. Large country houses were becoming an encumbrance rather than a status symbol. But such freedom from constraint does play an important part in the plot of many of the novels. Individuals with wealth to leave can and do exercise control over their families by means of promises as to what each will leave or threats of disinheritance. And again, linking back to the women's legal landmarks, this in turn leads to new debates about whether the possibility of leaving property away from your children should be constrained.